Good afternoon. My name is Susie Allen. I'm an employment solicitor here at gunnercooke. Thank you very much indeed for joining me on this webinar on Pimlico Plumbers and the gig economy and what next for employment status. Just to give you a little bit idea of how it is that I've come here today to be talking to you about this subject. I recently joined gunnercooke in the middle of January this year. Gig economy has been, and employment status has been a bit of a project of mine for the last 18 months or so, because when I returned from my last period of maternity leave in autumn 2016, I came back to work off the back of the very high profile decision against Uber in the employment tribunal that deemed that their drivers were workers. And also a query from a client who also happened to be a private hire taxi firm requesting, well, what are the implications of this decision for us? And since then, gig economy and employment status has been a bit of an ongoing, some might say slightly over-enthusiastic fascination of mine. The reason why I wanted to talk to you about this today is because I'm conscious that it is still a very high-profile area of law. There have been some high-profile cases, and we're still awaiting for some of those cases to make it all the way through to the Supreme Court and receive the decisions in that regard. I'm also conscious that the decisions and the government's response as to what they're supposedly going to do has been a little bit piecemeal. So I thought I would use this as an opportunity to revisit some of the recent cases and give you an idea of what to expect in the future. I'm aware that you can pose questions to me as we go along. I think I'll try and answer those as and when, if it's convenient and appropriate to do so. If I don't answer your question, I will pick it up with you at the end, but please feel free to pose any questions you would like. In terms of what I'm going to cover, I'm going to be talking about the distinction between employees, workers, and those that are self-employed. Now, there are other categories of employment status, such as agency worker and apprentices, for example, which I'm not going to talk about today. The focus is really going to be about what is the definition of an employee, a worker, and someone who is self-employed, insofar as we can neatly describe that, and in particular focus on why the distinction between workers and those that are genuinely self-employed has been so problematic and why there are so many cases on that point. The reason why this is important is because an individual's employment status will obviously dictate what rights they have, and I will talk to you about that in a little bit of detail. A key part of this webinar is going to be an overview of some of the recent high-profile cases, and I thought it would be beneficial to you that before we talk about those cases, we have a quick refresh, if you like, without teaching you to suck eggs, but we do a little bit of revision as to what the law says about employment status. And as part and parcel of that, we'll see why it has caused the tribunals and caused some problems in terms of determining whether someone is an employee, worker, or self-employed. Then we'll look at those cases. And I also wanted to talk to you about the Taylor Review, which came out last year, and the government's response, which has been recently announced. As part and parcel of this, I thought it would be helpful to you to help you not only understand how you can establish someone's employment status or whether they are self-employed insofar as possible, but also think about the ways in which potential risks can be mitigated, particularly if your organisation engages people on what is deemed to be a self-employed basis. Now, I mentioned earlier on that we're talking about employees, workers, and the self-employed. We'll come on to the definitions in due course, but before we go any further, it's worth bearing in mind what are the consequences of someone who we think is self-employed actually acquiring worker or potentially employee status. And the consequences effectively are that an individual potentially acquires a number of rights and potential claims that they can pursue before the employment tribunal. And you will see that obviously the employee almost has the highest status of all. They have the most entitlements. And in particular, it is only employees in the strictest sense who can benefit from rights being implied into their contract. For example, the implied right that the employer will not treat them in such a way so as to breach their trust and confidence. It is, of course, also only employees in the strictest sense that can pursue a claim for unfair dismissal. Only employees are entitled to statutory redundancy pay and statutory sick pay. At this point, I will throw in two small words of caution in relation to statutory sick pay. There is a caveat that if someone who is entitled to Class 1 national insurance contributions, even if they are deemed a worker, they are potentially entitled to statutory sick pay. And as we will go on to see, whether a worker should be entitled to such pay anyway, regardless of their class of national insurance, if you like, is something that's been picked up by the government at the moment and may change. Finally, it's only employees that are entitled to family-related leaves and pay. So here I'm talking about maternity leave, paternity leave, shared parental, etc., and the associated pay. Again, there are certain circumstances depending on how a worker is treated for tax and national insurance purposes, which may alter their pay entitlements. But as a general rule, we're talking about employees only. Then we get on to the sort of categories of rights, if you like, that apply to workers as well. And this is where the spotlight has been focused by recent claims, because as we'll see, the claims really look at that distinction between someone who is self-employed and someone who is a worker, because if the individual manages to get over that hurdle and acquires status as a worker, then that kicks in their entitlements to potentially national minimum wage, entitlements under the working time regulations, and holiday pay has obviously been a very hot topic in recent claims. You might also find that individuals who are considered as workers should be counted in the headcount for the purposes of who is going to transfer under a TUPE transfer, because actually the definition of employee under TUPE is wider than it is elsewhere in law, and the most predominant and most relied on definition, if you like, is found under the Employment Rights Act, which we'll cover momentarily. But actually, TUPE is a slightly wider definition as it refers to any individual who works for another person, so that could potentially encompass workers. The Equality Act, so individuals who are protected by discrimination legislation, again, that is a wider definition of employee, so it could encompass workers. I should also add a little bit of a health warning there that in certain circumstances, contractors may also be protected from discrimination by their end user. So you could be looking at, for example, agency workers who are able to rely on the rights under the Equality Act. And whistleblowing, again, the definition of employee is wider and could potentially encompass individuals deemed as workers. So putting self-employed individuals back in the pot, as I say, if they are able to overcome that hurdle as to whether or not they are a worker, all of a sudden there are these increased entitlements, such as unlawful deduction from wages and holiday pay, to which they would not be entitled if they were self-employed. And this is where the case law has really developed. Before we go any further, let's remind ourselves of what an employee is defined as and how a worker is defined as well. And you'll see that it's not necessarily that straightforward, and hence why it has been problematic, and there are a lot of cases on this point. But just to go back to basics, and effectively we're looking at the definitions as taken from the Employment Rights Act. An employee is someone who works under a contract of employment, in other words, a contract under which they agree to serve another. That's fairly straightforward, and that's probably why you'll have heard of the phrase a contract of service. And that's often contrasted with a contract for services, and that's where we get into this grey area where have we got someone who's self-employed or a worker. Worker is defined as someone who works under a contract of employment or any other contract under which an individual undertakes to perform personally work or services to another who is not a customer or client of the individual's profession or business undertaking. Now, I appreciate that's not the pithiest and most easily digestible definition, and apologies to
make this sound a little bit technical or academic, but I think it's worth bearing in mind the words, and particularly the words that I've emphasised, because it's these definitions and those areas that have formed the crux of a lot of the case law, and in particular is their personal service, and is the end user of the services, the person that benefits or the body that benefits from them, are they a client or customer? And I think what I'd like you to bear in mind as we go forward, and certainly this is something I encourage clients to think about when they're trying to establish, are we dealing with someone that's self-employed, or have I potentially got a worker on my hands? If the definition of worker it boils down to whether or not someone is operating some kind of profession or business or operation for a customer or client. Are you a customer or client? And I suppose the purest example that you might find in that regard is if you hired someone to come and give assistance to your organisation, for example, in relation to some joinery or some plumbing or some construction. It could even be you need some updates to your website, you need someone on an ad hoc basis to look after your website and update it and correct it accordingly. And those types of individuals are most likely going to fall under the self-employed banner. And it's when we start to move away from that and what the individuals do effectively becomes more integral to what your organisation does. That is where the waters start to muddy, and we're potentially looking at someone who is not self-employed, but actually a worker. If we look at the tests in more detail and effectively the steps that the tribunal, the questions that a tribunal would go through in order to work out someone's employment status, you'll see that there are some factors that are common to both employee and worker. And the first of those is existence of a contract. Now, it seems like a fairly obvious thing to say, but I just wanted to spend a few moments talking about this because actually the starting point for any tribunal or court when assessing someone's status is the contract that's actually in place. And that's not necessarily a straightforward exercise. If, best case scenario, the contract, what happens in reality is reflected in the contract, then there's no reason for the tribunal to look behind it, and they will go with what the wording of the contract says. And if that contract explicitly says this engagement is on a self-employed basis, and there's nothing about the arrangement or the relationships or the intentions of the party that comes to light which indicates to the tribunal they should look beyond it, then they won't do, and they will go with that. However, it's not that hard for the tribunal to find an excuse, if you like, to look beyond the documentation. And this is because, obviously, relationships develop over time. Quite often, the contract on which someone provides services to another in whatever form is not neatly contained in one document. There may be other elements that are effectively terms or contractual terms that have been agreed, perhaps by way of separate email or letter or even verbally. It may also be the case that the way in which the parties treat each other is no longer reflected by the terms of that contract, and in which case the tribunal will look at the reality of the situation to determine, well, what type of contract are we looking at? Is it an employment contract, or is it genuinely a situation where the individual is engaged on a self-employed basis? When looking at contracts, tribunals will also consider whether the contract is a sham. Now, when I use the word sham, I don't mean to indicate that there has to be some kind of deliberate misleading of the other party. It's quite easy for the tribunal to find that the documentation is a sham if it simply does not reflect what was intended by the parties at the outset, or in effect what is happening in reality. The next point, so assuming the tribunal has got to the point where it says, well, okay, regardless of what the contract says, I think we need to look at actually what is going on between the parties. The next question is the individual required to provide their services personally to your organisation? And if so, that is an indicator of worker, if not employee status, depending on the other factors that they will look at. And personal service, in effect, what we're talking about is it has to be that individual that turns up to do the work. It can't be that they can send a substitute in their place. And ordinarily that would seem a pretty straightforward question, or sort of pretty straightforward to answer. But as you will see, personal service and the right of substitution has been problematic. And actually, even if a contract includes a right of substitution, that's not enough for the tribunal to go, okay, right, well, that completely obviates, or it gets rid of the fact that there's any personal service at all. What I should say at this point is that at present, the way the law stands, if an individual cannot convince the tribunal that they are required to provide their services personally, then their claim for worker or employee status is probably going to fail. So personal service is a minimum requirement of both types of status, and without it, it's fatal to any claim. If we move down the bullet points that I've compared between employee and worker there, you'll see that we then get to, on the worker side of the page, we get to the question of whether the party to whom the services are provided is a client or customer. So effectively here we're talking about whether you take or engage someone to provide you with a particular service, and you in effect are their client or customer. And as you'll see, Uber became very unstuck on that point. And one of the issues that the tribunal will look at in this regard is how integrated the services that the individual does are within the services of your own business. And I suppose another way of looking at it is, well, what is it that our organisation does? And can we do it without these individuals? And effectively, if that is the case, then that's going to put quite a big question mark over whether or not you are this individual's client or customer. That's not to say that a claim for employment status is definitely going to succeed if that is the case, but it's one of the factors to bear in mind, because ultimately the tribunal is going through these steps and these questions and doing a balancing act to see whether, when applied to the facts, the result is that it tips the balance in favour of someone being self-employed or perhaps towards worker and potentially employee. The next issue they will look at is whether there is mutuality of obligation. Now, by mutuality of obligation, what we mean is an obligation on the organisation to provide work to the individual and an obligation on the employee to accept it. Now, it's not unusual to have a scenario whereby an individual isn't obliged to be available to pick up work at a certain time. Offers of work may be made to them and they can ignore them or turn them down, or pick them up at their request. That would tend to point towards self-employed status, but it's not necessarily that straightforward, as we will go on to see. And you need to be mindful of your conduct towards individuals, both between assignments and during assignments, because once they have picked up work, i.e. they've agreed to do it, it may be the way that you have treated them from that point means that they are at least a worker for the time they are providing the services or during that assignment, if not between assignments as well. And we'll look at that in a bit more detail when we examine the cases. Now, the final two factors that the tribunal will look at are control and other factors. And this is really where you start to get the distinction between what is deemed as worker and what is deemed as employee status. And the greater the degree of control, the more likely you are to have that higher status of employee. And there are some other factors as well that will tip the balance away from someone being simply a worker towards being an employee. These control and other factors, which I will talk about in a bit more detail in a moment, are not just important in terms of whether you are questioning whether someone is a worker or an employee, but they will also be taken into account in relation to whether someone is providing services to a client or customer, and could also affect mutuality of obligation. So I suppose the point I'm trying to make is that actually some of the facts that you apply to the test will be relevant to more than one part of that test, and whether or not there is mutuality of obligation may also dictate or contribute to a finding that your organisation is not the client or customer of the individual, and it's unlikely that they are self-employed. And the reason why that is that ultimately, if someone is operating with you and you're supposed to be their client or customer, you shouldn't really be exercising control over them. They should have autonomy and freedom in what they do, because control effectively is the extent to which the so-called employer, if you like, tells the individual how to do their job, in what way to do their job, what tools or what format they should do their job in, elements of supervision, and that the greater the level of control, the more likely they are to be not just a worker but potentially an employee. In terms of other factors, by way of example, the tribunal will be looking at integration into the business. So it might be that an individual has to wear a particular uniform. It might be that the individual is issued with their own email address. Other factors that a tribunal would look at are who bears the financial risk, and that's been a key point in the cases we'll go on to look at, because actually, if it's the organisation that bears the financial risk, for example, if a client doesn't pay, or if an individual gets the work wrong and has to redo it, if that individual is paid regardless, and if the organisation is responsible for collecting all funds and paying them to the individual, that is going to lead the tribunal away from a finding that someone is self-employed. Now, we've spoken about the tests and how we distinguish between worker and employee. And of course, that's important in this context because the claims we're looking at are people who are supposedly self-employed who want to be labelled worker or employee and acquire the rights and entitlements that affords. So let's shine the spotlight now on that distinction between someone who is potentially a worker and someone who is self-employed. And again, forgive me for being slightly technical about this and drawing your attention to specific parts of the case law, but I think it's, as I say, it's worthwhile bearing in mind what the courts and tribunals actually say, so that you can apply the facts of your own organisation to the decisions, and also understand more clearly why it's such a thorny area of law. Because there is a quote that has been repeated on several occasions in the high-profile cases we'll go on to look at, such as Uber and Pimlico Plumbers. And it keeps coming back to haunters, and I thought I would put it on your radar because it neatly illustrates why it's so problematic. Because actually, the law recognises that there are two different kinds of self-employed people, one of which might be worker. So if we look at this quote in a bit more detail, got one kind carry on a profession or a business undertaking on their own account, and they enter into contracts with clients or customers to provide work or services for them. The other kind of self-employed people provide their services as part of a profession or business undertaking carried on by someone else, and that's a worker. So this comes back to the point I was making earlier, as is the individual actually carrying on or providing services as part of their own business undertaking, or are they carrying it out in order to help you further the services that you say your organisation provides? And I think that's the key distinction, and something that the tribunal will certainly look at in trying to decide, is someone a worker or self-employed? Let's go and have a look now at these high-profile cases that I've touched on. I suppose what I should say is that this is not every single case on employment status. It's not even every single case on employment status since the Uber decision back in autumn 2016. But I wanted to really give you the headline points and the high profile points and remind you what are the sort of outstanding issues so that you can, as I say, refresh your memory of them and I suppose update yourself in preparation for decisions that are due to come out in due course. So Uber, obviously, or their business model, if you like, is that individuals book services through an app, and effectively a driver turns up, a driver is logged onto that app as well, and the app automatically allocates jobs to the drivers, and effectively that's how their sort of taxi operating service, if you like, is built up. And the reason why the term gig economy is used in reference to companies, organisations such as Uber, and it has become so prevalent of late, is that this model of providing services electronically through some kind of digital platform, through an app, is obviously it's quite a recent phenomena and not unusual. And there are plenty of other companies that do it, and Deliveroo is another one that I'm going to talk about later. And it also dictates the way in which work is allocated and carried out. So we're talking about ad hoc, flexible work with no guarantee as to its frequency and duration. So that's what we mean by gig economy. And off the back of that, it's worth making the point that although a lot of the cases have involved companies that use apps to collect work, if you like, through which clients or passengers in this case can instruct services, and also to allocate those or assign those services to the drivers. Just because it's done through a digital platform, that doesn't mean that the gig economy and employment status, or the issues on employment status that I'm discussing today, are only relevant to that business model. The law on employment status has not, or the law on employment status that has formed the crux of these claims is still the same, and it applies regardless of whether you're a company that offers work through apps or electronically. So it's worth bearing in mind that yes, there will be some factual distinctions, but there will also be some factual points with which your company may align in the way that it offers services or assignments, if you like, to individuals. The upshot of the employment tribunal, so here I'm talking about the first instance employment tribunal decision on Uber, is that the drivers were found to be workers whenever they were logged onto the app and within a certain geographical area in which they were licensed to carry passengers. And effectively that's the within the London area, and we're talking about approximately 30,000 drivers, or it'll be more than that now because obviously this case is a couple of years old almost, but over 30,000 drivers who provide services through Uber. There were two claimants, so Mr. Aslam and another, who were picked out as, if you like, sample claimants on which their claims would be based going forward, on which the employment tribunal would make a decision, as those seem to be examples of the drivers at large. Now, as I've already said, the tribunal found in favour of the drivers that they were workers. And the crux of the driver's claim was that in the first instance, they weren't self-employed, as Uber were trying to make out. And as consequential to that, when you added up all the time that they had worked and the sums that they had received, they hadn't even been paid minimum wage, and they were also owed holiday pay. So those are the issues that the tribunal was looking at. Now, bearing in mind the legal tests that I covered earlier, the tribunal's reasoning basically started with the contractual documents. And as I was saying, the tribunal will consider, are they a reflection of the reality? And if not, do we have to look behind them? And what is the result of looking behind them? What is the reality of the relationship? And it didn't take much for the tribunal to start, or to feel the need to look behind the paperwork that was in place between Uber and its drivers. And in particular, you'll see from the slide that they found the paperwork to be fictitious, that the language was twisted, and there were also a lot of inconsistencies between the documents on which they were relying. There was a contract between the drivers and Uber. There were also various other contracts between Uber and potential passengers. What also led to Uber becoming unstuck is that in its marketing material, it described itself as a transportation provider, whereas elsewhere it was trying to describe itself as a digital platform through which others can provide transportation services. And they were completely inconsistent both between the documents themselves, their marketing material, their website, and the oral evidence that was given at the hearing itself. And the tribunal effectively said, well, you're just trying to make the story up retrospectively now to cover that you are this so-called digital platform, and that you're sitting in the middle of lots of drivers who operate individual businesses and they just operate through this digital platform. It's nonsense. It's effectively smoke and mirrors. You're misdescribing yourself. And there's a quote that comes up in the case that, again, is from an earlier case and it's repeated in some of the other cases we will look at, which is that you've effectively got an army of lawyers to draft the documents for you with a view to basically confusing or bamboozling the individuals that are signing up to them. The fact that Uber had gone on to describe itself as a transportation provider was critical, because if you recall a moment ago, I was saying we have to think about what does our business do and what does the business that this individual, what are the services that this individual is carrying on, and are the two integral to each other? And by effectively having to concede that it was a transportation provider, Uber also had to concede that it was responsible for transporting people from A to B. If it had described itself more carefully as simply facilitating the transportation of passengers from A to B and offering a system through which bookings can be made and passed on, we'll potentially be looking at a slightly different outcome. But I think what it highlights is that you need to think about how integral are those individual services to what your organisation says that it does, and how do we describe ourselves. Personal service was also a big issue in the Uber case, and the way in which Uber fell down or the decision was held against it. And the reason why this was the case was because the drivers had to use a specific PIN or a personal logon number in order to get onto the app, and they were prevented from sharing it. So in the first instance, that virtually made it impossible for them to appoint a substitute to carry out a job for them because they couldn't pass on the logon details. What was also notable is that the driver was effectively punished if it didn't carry out a job once it was accepted. And again, that makes it very hard for the individual to pass a job on. In other words, once you have agreed to do something, it has to be you that carries it out. Now, I appreciate that the factual backdrop of having to have a personal login and PIN is only relevant to companies that operate in a sort of digital manner. That said, how you treat an individual once they have accepted a job and how you enable them or potentially prevent them from appointing a substitute at that point could potentially point towards personal service. Because even if you say, okay, yeah, you can appoint a substitute, if it's restricted so that they can only do that before they've accepted a job, then it's almost like the substitution clause is completely meaningless, because you're already at the point where they can decide whether they want to, put themselves on notice or log on to see what bookings are available. Whether or not someone else does that instead of them before that point is, you're never going to be aware of that, and it's completely irrelevant. We'll look at that in a bit more detail later on, as I say, because personal service was the crux of the Pimlico Plumbers decision. Other factors that weighed against Uber in this case, and in particular led the tribunal to find that Uber could never be a client or customer of the individual drivers, was again the overlap in services that they both provided. In effect, Uber needed the drivers, it needed a pool of drivers to be available as and when, otherwise its business could not operate. What was also significant was that Uber handled all monies and in particular bore some financial risk. So, for example, if a journey was booked fraudulently through the app and someone's login details, so we're talking about a passenger here, say someone fraudulently booked a journey on their behalf and money was taken from their account without them knowing it, Uber would remedy this. If there were any complaints from passengers which potentially resulted in a refund, again, this was handled by Uber. There was no input from the driver, and Uber didn't pass on the financial risk to the driver. And that, as far as the tribunal was concerned, was not equated, or not to be equated, with self-employed status. Another issue that led to the finding against Uber is that it effectively operated a sort of pseudo-disciplinary policy against the drivers. And certainly if you are looking for someone to be self-employed, you should avoid operating anything that is akin to any kind of performance management or disciplinary. The mechanics of it were fact sensitive to this case, because it was effectively, if you agreed to do a job and then refused to do it or said you weren't going to do it, then you would be logged off the system, which meant that you effectively lost the opportunity to pick up passengers and therefore make money for a window of time. Okay, that's fact specific to Uber, but I suppose the overall point to make is, if any of your treatment towards an individual could be deemed as potentially punishing them if they don't pick up jobs or don't do them within a certain amount of time, then that could lead a tribunal to a similar finding that, if you were their client or customer, you would never treat them in that way. Another point, and this is something, again, it's fact specific to Uber, but I've come across it quite a bit in clients that have asked me about employment status, is where the organisation produces invoices on behalf of the so-called self-employed individual. And again, the tribunal said it's ridiculous that, if you handle all the monies and you supposedly invoice the driver invoices the passenger but never actually gets to see the contents of that invoice. Again, it's complete sort of fabrication, and it's false, and it's not something that points towards self-employed status. Uber has, of course, been appealed and gone to the EAT, and for any of you that have potentially had the opportunity to look at the judgment, and don't worry if you don't share my same weird fascination with gig economy and you've not done this, but when I read it, effectively it read as if the EAT was, it had to find a very good reason not to find in favour of Uber, otherwise it would just rubber stamp the previous decision. So, as is indicated in the slide, it effectively said that the Employment Tribunal had been right to consider the reality of the relationship, and in particular the paperwork, as it did, and its findings of fact absolutely supported its judgment. Some key points that came off the back of the EAT decision, if you like, where it built upon the earlier first instance decision, were that, it could never be that the drivers were operating their own businesses and Uber were clients and customers, because in the first instance, if you look at the scale of the operation, you've got 30,000 individuals operating through one digital platform. It seems highly unlikely that we're going to have 30,000 individual and separate businesses that operate in such a way. Secondly, the scale of the operation was such that if a driver wanted to provide his or her services in a similar manner but not through Uber, it was virtually impossible. It was almost like they monopolised the market. Other factors of note were that the Uber never shared passengers' details with the driver, so the driver had no ability to negotiate directly with the passenger, both in terms of the price and location, and I suppose the way in which the services would be carried out. And again, that's not a situation that you would equate with someone that's operating a business on their own account. And effectively, the drivers they had to accept Uber's terms in order to be able to use the digital platform, in order to be able to be given access to the app to carry out those services. So they had no choice to agree. And you'll see as we go on that the equality of bargaining position is another factor that tribunals will take into account.
Dewhurst and against City Sprint came out a few months after Uber in early 2017. And again, it's a first instance employment tribunal decision. Brief backdrop is that the claimant was a cycle courier, and in particular, its packages within the medical industry. And again, her claim is in relation to, in the first instance, I am a worker and not self-employed, as City Sprint say that I am. And number two, as a result of that, I'm entitled to and I am owed holiday pay. Again, the Employment Tribunal found in favour of Ms Dewhurst and found her to be a worker. The reasoning in support of this, again, they looked back at the contractual documentation and they found that it was problematic in that there was a lack of bargaining power. The format and the process through which Ms Dewhurst and other couriers signed, and I've put signs in inverted commas, is specific to City Sprint, but because they effectively they were showing the contracts by way of web pages. I think they had to click through them, and then they effectively pressed a button at the end to say that they read it. And if you look at the case in a bit more detail, Ms Dewhurst describes how she was effectively sort of rushed through the contract, wasn't really given the opportunity to read it, and was basically under the impression, if I don't sign this here and now, I'm not going to be given any work by this company. So again, there's a complete lack of bargaining power, and in effect, if you've got an individual who is operating a business on their own account, they're operating their own business, they should be coming into this arrangement on much more equal footing with you if you're supposed to be their client or customer. Personal service again was an issue for City Sprint. It was a particular issue here because the sensitivity in terms of what the couriers were carrying around, medical supplies, and the buildings in which they had to go. And because it was sort of identity sensitive, it meant that Ms Dewhurst and none of the other couriers could ask anyone to go in their place. They couldn't send a substitute. So there was personal service. There was an obligation to provide their services personally to City Sprint. Other factors that were taken into account were that City Sprint clearly had too high a degree of control over the cycle couriers, which again pointed against them being a business on their own account. They were told what to wear and what to do. They were even told to smile and how to behave with the end user clients. They were kept out of the payment mechanisms, and what was particularly noticeable is that the couriers supposedly had to check in to the operations centre. They had to call into the operations centre to get permission to go home. They also effectively had to notify them of when they were going to take holiday. Now, if you compare this to what you ought to see in a scenario where someone is genuinely self-employed, someone who's genuinely self-employed should have freedom to choose as and when they work and when they take holiday, and shouldn't be under an obligation or shouldn't have to ask permission to go on holiday. I mean, they may tell you as a matter of courtesy, but if you start imposing any situation, even if just implicitly, that unless someone tells you when they're going to be available or does a minimum amount of hours or days or work, then you're almost implying that there is mutuality of obligation. That person, as bare minimum, has to do a certain amount of work and has to be available at certain times to accept that work. Otherwise, they won't be offered jobs in future. And that was effectively the consequence of Miss Dewhurst not giving such notice. And as I say, not only did it point against her being someone in business on her own account, but it also led the tribunal to a finding that mutuality of obligation was there, and sufficiently so as to point to her being a worker. Pimlico Plumbers, which obviously forms one of the core cases at the heart of this webinar. This was a particularly high profile case because it was a Court of Appeal decision, so it's a higher level than the ET and the EAT, the decisions that I've spoken about. And also the Mr Mullins respondent is the same Mr Mullins who supported Gina Miller in the Article 50 Brexit case, so it did attract quite a lot of attention. Now, the law that the court went over and that formed the root of the previous decisions isn't new, but there are some factual specifics to this case which are interesting and ought to be borne in mind in terms of bearing or trying to assess your relationship with contractors going forwards.
Again, Mr. Smith was found to be a worker. His case was actually wider than just worker status. He was trying to plead that he was also an employee, but on balance, it was found that the distinction, the amount of control that you would exercise over an employee wasn't there. Nevertheless, there were specifics to the relationship which meant that, in effect, he had to be available to do 40 hours a week, even if Pimlico Plumbers didn't offer him this amount of work. And there were various ways in which the tribunal reached that decision. It was partly due to some of the wording in the contractual and policy-related documentation, but also because of once it took into account how much money the claimant had to pay out in order to hire his van and get his tools. He had to work a considerable number of hours a week, even just to break even. So that in itself implied this obligation for him to be available, at least agree to pick up a minimum amount of hours. So again, we're looking at mutuality of obligation there. The Pimlico Plumbers also required him to wear a particular uniform and use a Pimlico Plumbers branded van, so this points to integration. They also drafted restrictive covenants into the contract with the plumbers. Now, I think the individual, he wasn't able to provide plumbing services within a particular area in London within 3 months of the contract coming to an end. And this decision is quite clear that you would not expect to see that if you're engaging someone genuinely on a self-employed basis. And again, that points to the plumbers not being business on their own account, as does the fact that Pimlico Plumbers Limited, the respondent here, it's very clear what they do. They provide plumbing services, and Mr. Smith was a plumber. So if we ask that question, like how integral are the services that the individual provides to the services provided by the business, it's pretty clear that they form a core part of it here. The headline issue that came out of Pimlico Plumbers' case is personal service. And what's quite interesting is that there potentially was a right of substitution here, but the Court of Appeal and also the tribunal and the EAT beforehand had effectively found that it was no more than being able to swap shifts as employees would. So it wasn't a completely unrestricted right to substitute. And in this case, the Court of Appeal gave some useful guidance of what may and may not amount to personal service. Unfortunately, it's not 100% clear cut, and again, it's going to be a case of taking the legal test and filtering your facts against that. But at face value, if you've got a completely unrestricted right for the individual to provide a substitute, that's highly unlikely to be an obligation to provide their services personally. If the right of substitution is subject only to the restriction that the individual needs to show that their substitute is as qualified as they are, then that's probably going to be enough to be a sufficient right of substitute so as not to amount to personal service. And it may be that the individual has to tell you as a matter of courtesy that someone else is going to do the job, and understandably you want to know that they've got the qualifications, skills, experience, etc. to do that. But if that's the only restriction, then again, it's probably going to be sufficient to defeat any claim that there is sufficient personal service. However, the more restrictions that you apply to that right to substitute, the more likely it is that a tribunal will find that that individual has to provide their services personally. And in particular, if they can only send a substitute when they're not able to carry out the work, in other words, if they can't just go, do you know what, actually, I don't feel like doing this today, or I think it would be better if that person went in my place, which is much more flexible. If they can only send the substitutes when they're actually unable to do the work, for example, they are sick, then that's not necessarily an unrestricted right of substitution. So again, you might be looking at personal service there. And if at the end of the day, so in this instance, Pimlico Plumbers can turn around and say, it doesn't matter what the contract says, ultimately it's down to me as to whether we say yes or no to this substitute. Again, that would point to a requirement of personal service. At this point, I just want to draw your attention to the decision in the Court of Arbitration earlier this year in relation to Deliveroo. And this was, again, it came up in the press. The Court of Arbitration, it was to do with whether or not union membership should be, or sorry, union should be recognised in respect of delivery. And delivery, of course, they are another company that provides services through an app. It's effectively a takeaway services through various restaurants. You order the food through the app as a customer, and then the various jobs are allocated onto individuals. Predominantly, you've probably seen them riding around on bikes to deliver that food to you. In order for the CAC to agree that the union should be recognised, the riders had to be workers. And there were a lot of things in this matter that weighed in favour of that. But the reason why the claim fell apart, the reason why they were found not to be workers, was because of the right of substitution. And what's notable about this example is that even after a rider had agreed to a job, it could pass it on to another person. And delivery effectively could not say no to that. It pointed to examples that had happened in practice, whereby an individual had to agree to do a job and then had said, actually, do you know what, I'm going to get this person to do it instead. As a matter of courtesy, they had to tell delivery who that individual was, just so delivery could trace where the food was going and that it got there to the right place and on time. But other than that, it was an unrestricted right of substitution, and the claim for worker status fell apart. So that's why I was saying earlier on, the timing of when someone can appoint a substitute is important. It's not just about whether an individual logs on or agrees to make themselves available for offers of assignments. If your right of substitution allows someone to agree to do some work and then subsequently says, no, this person's going to do it instead, that's going to be quite hard for that individual to demonstrate that there is personal service, that there is an obligation on them to provide services personally. Now, CAC decision isn't binding on tribunals, but the reasoning there as to the right of substitution and the freedoms that it's afforded, I can see it being used in future cases on employment status. So I wanted to put it on your radar. The final case I wanted to cover was against Addison Lee. There have been a couple of cases on Addison Lee. This one is dealing with the taxi drivers and not the couriers. The important things to take from this case are that effectively, whether or not mutuality of obligation exists, i.e. whether or not there's an obligation on the organisation to offer work and an obligation on an individual to accept it, it's quite a low hurdle to overcome. And what the tribunal found here was that there were a number of factors in the arrangements and in the run-up to a driver being in a position to accept work that effectively meant, of course, Addison Lee were undertaking to offer work to that individual, and of course that individual was undertaking to accept any such work offered to them. And the reason why they found this was because the drivers had to hire a car from Addison Lee, so it was very specific in that regard. So they were all already committing themselves financially before they'd even picked up their first job. They could not use that vehicle for any other commercial or income earning purposes. And effectively what the tribunal said was that, well, if the drivers didn't accept any work at all, then Addison Lee's business model just wouldn't work. So of course they must have expected to offer some work to these individuals, and of course there must have been an underlying obligation on those individuals to pick it up. So I think when I first read that, I was like, well, that's going to be quite hard for any business to argue otherwise, because if you need someone to do a particular service for your company to continue in its business model, then that mutuality of obligation is going to be there. Other factors that weighed in favour of a finding of the drivers being workers here were the amount of work that the drivers had to do and basically regularly found themselves doing. It was 40 to 50 hours a week, if not more. Part of that was to cover the vehicle hire, so there was an underlying obligation for them to carry that minimum amount of work out, as there was in the Pimlico Plumbers case. And I suppose the regularity and repeated nature of those hours also, again, points to there being this obligation to work at least a minimum number of hours per week, which is not something you would equate with self-employment status. So those are the key cases, as well as the case law. We've obviously seen some developments from a government point of view, albeit I wish I was able to sit here today and tell you exactly what's going to happen in relation to employment status and confirm that the government has set a more concrete path to help us decide whether someone is self-employed or not. Unfortunately, that's not the case. The Taylor Review, you may recall, this was commissioned by the government. It was effectively a review of working practices and the workforce, and in particular, it looked at the gig economy and issues that were coming about because people were supposedly supposed to be self-employed when actually they should have been treated as at least a worker. Off the back of the Taylor Review, I don't want to spend too much time on this because what you'll see in the next slide is that the recommendations weren't necessarily all picked up by the government. A key recommendation was that because of the confusion over what's an employee, what's a worker, what's a contractor, Taylor recommended, well, why don't you rename workers as dependent contractors? Why don't we set out in law what each status actually is and clarify it. It also suggested additional protections and in effect the key point was to do with the clarification of what is a worker and what is an employee and so on. But it also suggested that perhaps there ought to be a higher rate of national minimum wage for people on contracts where their hours were unguaranteed. Individuals who are on 0 hours contract after 12 months, should they be entitled to a contract which affords them a guaranteed minimum number of hours. Now, what we were hoping for is that off the back of that, the government would put forward some draft, even if in draft form, but some draft legislation saying, okay, well, this is, either we are going to adopt this independent contractor terminology that Taylor has suggested, and this is what it's going to look like, or we're going to stick with employee, worker, and self-employed, but we're just going to be clearer as to what they mean. But we unfortunately have not got to that situation yet. There are some things that the government has proposed it is going to do, and that's that a right to a written statement of terms will be extended to all workers. So this is effectively the right to have your contract to employment or certain factors of your contract to employment set out in writing. That should apply to workers and not just employees. There's also the introduction of the obligation to provide itemised pay slips to workers, and if they're paid on an hourly basis, payslip must state the number of hours paid, and obviously this comes off the back of issues that workers have encountered in trying to calculate what their holiday pay is supposed to be if they work irregular hours. You'll also see that the Low Pay Commission, or subdivision of the government, if you like, is considering what the impact of introducing a higher rate of national minimum wage and living wage for those on unguaranteed hours, and we should hear later in the year what the outcome of that is. And then the next 2 points, so the 1 week gap between assignments to preserve continuity of employment will be increased. So just to recap what this means, if there's a gap of more than 1 week between periods of service, then at the moment that could be enough to effectively break the chain of someone's continuity of service. And for example, it might defeat them bringing a claim of unfair dismissal because they haven't got 2 years continuous service. And then finally, the pay reference period. So that's the period that you would look at to calculate someone's average wages, is potentially going to be increased from 12 weeks to 52 weeks. So you'd look at the whole year of an individual's earnings to work out what their average is. And again, I think this is because people who are paid on an hourly basis and work very irregular hours on an ad hoc basis may have quite long periods in a 12-week totality in which they haven't done any work, but if you looked in the 12 weeks before that, they've done a lot of work, so 12 weeks isn't necessarily an accurate reflection of their average earnings. However, as I say, we haven't really got any further on a guaranteed clarification of employment status, because as this slide demonstrates, all that the government has done is opened up consultation on whether the current test is still relevant, should they be set out in law, i.e. sort of harmonised, so that they're clearer, and also be reflected by the test that HMRC applies, because at the moment that they don't necessarily coordinate. There is an overlap, but they don't necessarily coordinate. And just because HMRC decides someone is an employee, it's not binding on an employment tribunal, and it doesn't mean that they will necessarily make the same finding, which is obviously very confusing. There's also consultation on whether less emphasis should be placed on personal service. So this goes back to the point that I was making, that if you are pursuing a claim in relation to employment status and you are unable to establish personal service, i.e. an obligation that you provide your services personally, that's going to be fatal to your claim. In future, subject to what comes off the back of this consultation, it may not be so straightforward, but that's the law as it stands at the moment. And then you'll see that the other consultations pick up off the back of some of the Taylor Review's recommendations, but unfortunately and disappointingly, we haven't got as concrete a solution as we were hoping for off the back of the Taylor Review, and we'll still have to watch this space. The same can be said in terms of the case law, because Pimlico Plumbers, part of me was hopeful that the Supreme Court's decision in Pimlico Plumbers would be out by the time I was speaking to you today, but it has been pushed back to later in the year. So the Court of Appeal's decision that I spoke about earlier in this webinar has been appealed. It's not on every single point, but it's going to be a decision from the Supreme Court. So it will be helpful to see what their view is on these thorny issues that are creating difficulties in establishing the distinction between employment status and those that are self-employed. As a final point, hopefully what will have come off of the back of that overview is that there are certain steps that organisations can take if they are concerned about people that they have or that they engage on a self-employed basis. If you regularly use contractors and you're concerned about the potential for those individuals to bring a claim, then the question is, well, how can we mitigate some of those risks? My recommendations would be at the outset of any relationship, so when you're thinking of engaging someone, obviously there's a benefit to being able to do it on a self-employed basis, because it obviates the need to have to pay or calculate things like holiday pay, and also that obviously they're not entitled to certain elements of pay. They're certainly not entitled to sick pay, and you wouldn't trigger the requirements to enrol them into any kind of pension scheme. That said, if you are effectively trying to engineer a situation where someone is self-employed, it could unravel in future. So my recommendation would be to have a think about some of the alternatives that are available to you if you're dealing with work that you can only offer on an ad hoc and flexible basis. Now, 0 hours contracts that I've mentioned there have come under a bit of flack, but they're not unlawful, and when applied correctly, they can be very effective. And actually the Taylor Review recognises that there is a place for 0 hours and hours contracts and casual working and flexible arrangements, and even to self-employed scenarios. So don't be put off considering those types of contracts because they've received a degree of negative press recently, but just bear in mind that during assignments an individual may acquire worker, if not employee status, and the associated rights that entails. Make sure that your paperwork reflects the reality of the situation. That said, don't be drafting it in such a way that you're trying to disguise or you're effectively painting a situation where someone's self-employed when they are not. Given the upshots of some of the cases I've discussed, before an individual signs it, they should certainly not feel that they are under any duress to do so, or in a position where they don't really understand it. So if people are in any doubt, certainly encourage them to ask questions and potentially take their own advice if they have to. Ensure consistency in terminology, both in terms of how you describe what you do, what the individual does, and how those individuals are described amongst your workforce. If there's an understanding that they are self-employed, if it's clearly stated that they are self-employed, they are contractors, then there isn't an expectation of integration into the workforce. If you're clear on the services that you provide and your documents and your marketing materials are consistent in that regard, and you can distinguish it from the services provided from the individual. That's going to be helpful. Make sure your substitution clause is as unrestricted as possible, and in particular that an individual can send a substitute in their place even when they have agreed to pick up a particular assignment. Off the back of that, be careful, be mindful of situations where individuals are only providing services to your organisation, because ideally they should be able to market their services to the world at large and be providing their services to other organisations, as that would be akin to a self-employed situation. With that in mind, avoid, insofar as you can, the same person doing the same hours, doing the same days, doing the same jobs, working for the same people. I should add a word of caution that none of this should be done in such a way so that it's obvious that you're trying to avoid a finding of someone having worker or employee status, but just be mindful of anyone that appears to be working for you continuously, because the merits of their claim may be stronger. And as I've mentioned previously, make sure there's nothing that prevents the individual from working for others and marketing themselves at large, because that would point to them having their own business or carrying out business on their own account. Avoid any system of supervision or performance management. If someone is self-employed, they should be responsible for what they do and the quality of their work. They should make sure that they have received sufficient training and paid for and undertaken the qualifications that are necessary. And if you find that they haven't, or that they are not up to scratch, then simply don't offer them the work anymore. And insofar as possible, in an ideal world, someone who is self-employed would handle the money they generate. Insofar as your organisation handles it, it's simply just a conduit through which the money passes. So the individual earns exactly the sum that relates to the services that they have carried out, and ensure that they bear some financial risk. For example, if you are not happy with the work that they have carried out, or if an end user client isn't happy with the work that's carried out, the self-employed individual would have to remedy that at their own time and expense. Now, it's clear that it's still something of a grey area, and that we haven't yet got the clarity we were hoping for in relation to employment status. So off the back of the webinar, I would say if you do have any queries, I see a couple of queries that will come through that I will deal with separately. If you do have any queries or you do want any more advice, please do feel free to get in touch, as I'm more than happy to help. Otherwise, thank you very much indeed for joining me on the webinar today, and I hope you have a good afternoon. Thank you.